can you search a bag under the motor vehicle exception if that bag was taken out of the car before you had PC to search the vehicle? My name is Anthony Bandiero, attorney and senior legal instructor, broadcasting live from ICP 2024. All right, in Boston. So this is a cop from Texas. He says, all right, so a discussion came up during our K9 training group of being able to search a person's personal property, backpack, purse, etc., if it was removed from the vehicle prior to the free air sniff and alert by the K9. The officer says, my understanding is that if it was removed prior to the free air sniff and alert, you would have to obtain a search warrant to search it since the PC was established after the property was removed. Some in the group believe that the property could be searched under the Carroll Doctrine or motor vehicle exception, since it was had just been in and removed from the vehicle. Can you point me in any case law for a situation like this? Okay, so the answer is I do not teach searching this under the motor vehicle exception. The problem is that's not the motor vehicle exception, right? I mean, the motor vehicle exception is probable cause, that there's evidence in the vehicle, right? And the place search is reasonable to believe that evidence could be found, right? So, but it's in the vehicle. The motor vehicle exception does not, does not pertain to passengers, right? People are not containers, so we know that, or occupants. It does not pertain and deal with the car right next to, so the point is, where does it end? It ends at the shell of the car. A good case for this is Cleveland versus State. It's a case out of Indiana Court of Appeals, 2019. And let me just read a quote to you and see if this helps. It says, here it is undisputed that the officers had the authority to invoke the automobile exception to search the Ford Explorer, and its contents therein. However, Cleveland, our suspect, contends that the automobile exception did not extend to his person or his gold bag because he had left the vehicle. Listen to this, what is most pertinent to our analysis is the fact that Cleveland and his gold bag were inside the vehicle at the time that the officer suspected the vehicle of containing contraband. By virtue of the bag's presence inside the vehicle, the officers had the constitutional authority to search it from the outset. Okay, so that's what's key, okay? So when we go back to our scenario with our officer, talking about the K9, alert, if the officers allowed him to bring that bag out and detain him outside the vehicle, I gotta tell you, I think the better way to do this is either A, consent. Hey, the dog's alerting on your bag, you can sniff the bag if you have reasonable suspicion, right? Obviously, this is a reasonable suspicion case, right? You can get consent, you can get a warrant. You may be able to do a search instant to arrest, but that's going to be tricky because he's probably not going to be near the bag at the time he's arrested. So you probably, if you're getting a search instant to arrest out of it, you're probably playing games, quite frankly. You're probably moving him near the bag, then you're saying you're under arrest in order to have a proximity with him in the bag in order to invoke that search instant to arrest doctrine, which I don't think is going to work. So, look, if you have other cases on this, let me know. That's fine, right? But at the end of the day, I personally wouldn't do it. He also says, okay, what about just ordering them to keep the bags in the car? Well, first of all, it could be a little tricky if they kind of scoot out of the car first to kind of get away. You have to detain them, down the block or something like that. But generally speaking, our scenario is if you stop a vehicle and you say, all right, guys, get out of the car, which you can get, right? The Pennsylvania versus Mimms allows you to order the driver out of the car, and Maryland versus Wilson applied that same doctrine to passengers. So you get the occupants out, and they're like, hey, I want to bring my bag, my purse, and so forth. My advice to you is, generally speaking, don't allow that, right? But don't allow it, not because you're trying to game the system and be like, oh, if I can get this PC on this, maybe that's where the evidence would be. Maybe that's a small piece of it, right? I don't think that logic is prohibited per se, but it's also just a huge officer safety issue. I mean, if the court has told us, the Supreme Court has told us in Mimms and Wilson that ordering people out or into the car, right, stay in or come out, is de minimis, meaning it's just not that much more intrusive than the actual stop itself, then how does that logic not apply to the person in the backpack, right? Isn't it also de minimis for everybody's safety just to say, hey, when I stopped you, the bag was in the car. How about we just keep the bag in the car? Doesn't that make sense, right? Isn't that also kind of like the least intrusive, right, means of like dealing with their property? Also, just use good old-fashioned Terry versus Ohio, right? We have also some safety issues here. So you have the intrusion is minimal, to say the least. As if you know, if there's any intrusion, right, it would be minimal. And also, we have a legitimate safety issue under Terry versus Ohio. Great questions. Keep them coming. Go to bluetogold.com/show, right? Go to our show page, ask your question, and I'll answer it in this kind of format and so forth. Also, if you have a question for me, you just want to ask offline, Anthony, I want to just kind of run something by you. I'm not going to give you legal advice. I don't want to become your attorney and get wrapped up in your cases, but I don't mind giving you legal education over the phone as well, right? That's for cops only, just so you know. I don't do that for the public. All right? All right, so keep the questions coming. If you like what I'm doing here, like, subscribe, tell all your friends about us, share with your friends. And until next time, my friends, you stay safe.